What are the elements of a premises liability case in NY? Facing the issues associated with premises liability law in New York can be a daunting task for anyone who has suffered an injury on someone else's property. Premises liability involves holding property owners and managers accountable for accidents and injuries that occur on their property due to unsafe conditions of which they were aware, or should have been aware. Premises liability law in New York. In New York, premises liability law pertains to injuries caused by unsafe, defective, or negligent conditions on someone's property. This law covers a wide range of scenarios, including slip and fall accidents, inadequate maintenance, defective conditions, and insufficient security leading to injury or assault. The overarching goal of premises liability is to protect individuals by ensuring property owners and lessors maintain a safe environment for all lawful visitors. The scope of premises liability extends to various types of properties such as 1. Retail stores. 2. Restaurants. 3. Private homes. 4. Public parks. 5. Apartment buildings. 6. Office complexes. Legal foundation for liability in NY. To hold a property owner liable under premises liability law, the following elements must be established. 1. Duty of care. The property owner or manager had a duty to maintain the property in a reasonably safe condition. This duty varies depending on the visitor's classification, e.g., invitee, licensee, trespasser. 2. Breach of duty. The property owner failed to fulfill their duty of care. This could involve failing to repair a known hazard, not warning of potential dangers, or neglecting to perform regular safety inspections. 3. Causation. The breach of duty directly caused the injury. This means the accident was a foreseeable result of the unsafe condition. 4. Damages. The injured party suffered actual damages, such as medical expenses, lost wages, or pain and suffering, as a result of the incident. First element: lawfulness of stay on property. Who is covered under the duty of care? This duty varies depending on the status of the person visiting the property. 1. Invitees. These are individuals who enter premises for a purpose connected with the business or other interests of the property owner. Invitees are owed the highest duty of care, including the responsibility to keep the property reasonably safe and to warn the invitee of any known dangers. 2. Licensees. These individuals are allowed to enter the property for their own purpose or as social guests and are owed a moderate duty of care. Property owners must warn licensees of any unsafe conditions that the owner is aware of and that the visitor is unlikely to discover on their own. 3. Trespassers. Typically, trespassers are owed the least duty of care. Property owners must refrain from willful or wanton harm to trespassers but are not required to keep the property safe for them. Premises liability exceptions for trespassers. 1. Child trespassers. Under the attractive nuisance doctrine, property owners might be liable for injuries to child trespassers if there is an artificial condition on the property that is likely to attract children, such as an unfenced swimming pool. Property owners must take reasonable steps to eliminate the danger or to protect children from harm. 2. Known trespassers. If the property owner knows that trespassers frequently enter the property, they may be required to warn these trespassers of dangerous conditions that create a risk of serious harm. Second element: proving ownership or control of the property. Legal implications of property ownership. Ownership implies a legal responsibility to address potential hazards, whether by correcting them or adequately warning those who might encounter them. This responsibility does not necessarily cease if the property is leased to another party. In many cases, both the owner and the lessee might share liability, depending on the terms of the lease and the nature of the oversight and control agreements stipulated therein. Determining control in complex property situations. Control can be established through 1. Lease agreements. These often outline who has responsibility for maintaining specific portions of the property. 2. Management contracts. These can show whether a property management company has taken over certain responsibilities that would typically fall to the owner. 3. Evidence of day-to-day operations. Receipts for repairs, maintenance logs, and employee testimonies can illustrate which party was actually managing the property.
Ownership versus management. Who is liable? 1. Property owners are liable for issues that arise from the inherent condition of the property or from areas of the property not specifically relinquished to the control of others. 2.
Management companies can be held liable when they have assumed responsibility for maintaining and securing the property, especially if the negligence directly relates to their management duties.
Third element. Demonstrating notice of the hazard to establish negligence. Constructive versus actual notice. Understanding the difference.
Actual notice means that the property owner or manager was directly aware of the hazardous condition. This can be proven through communication records, such as emails, maintenance requests, or verbal acknowledgments indicating that the hazard was reported to and received by those in charge. Constructive notice is inferred legally when a condition has existed for a sufficient length of time that the owner or manager should have discovered it through reasonable inspections. Constructive notice does not require proof that the owner or manager was directly informed of the hazard. Instead, it focuses on whether the hazard was obvious enough that it should have been noticed and addressed.
Documenting the timeline of notice. 1. Identifying the creation of the hazard. When and how did the hazardous condition begin? Was it due to an immediate incident or a gradual deterioration? 2. Tracking reports and complaints. Gathering any reports, complaints, or communications that indicate when the hazard was first reported to management or property owners. 3. Assessing response times. Evaluating how long it took for the property owner or manager to respond to the hazard, if at all, which can influence the determination of reasonable action or negligence. A well-documented timeline not only helps establish notice but also supports the plaintiff's case by showing the duration for which the hazard was ignored. Proper maintenance records can either defend a property owner by showing diligent upkeep and timely response or can substantiate a plaintiff's claim that the owner failed in their duty to provide a safe environment. Fourth element, linking the hazard to the injury. Proving direct causation in injury cases. Direct causation is a legal term used to establish a clear and unbroken chain between an act, or a failure to act, and an injury sustained. In the context of premises liability, this means proving that the injury was a direct result of the hazard on the property. 1. Immediate connection. Showing that the injury occurred in a manner that is logically and temporally connected to the interaction with the hazard. 2. Exclusion of alternate causes. It must be demonstrated that other potential causes could not have led to the injury, thereby solidifying the property hazard as the primary cause. 3. Expert testimony. Often, premises liability cases require testimony from safety experts, engineers, or accident reconstruction specialists who can help establish how the hazard led to the injury. The significance of medical evidence in proving injury. 1. Medical records and reports. Documents that detail the injuries sustained, treatments prescribed, and the prognosis. 2. Expert medical testimony. Specialists in fields such as orthopedics, neurology, or physical therapy may be required to testify how the specific injuries are consistent with the accident described. 3. Documentation of recovery and rehabilitation. Records of ongoing treatments that can help demonstrate the long-term impacts of the injury, further tying the severity to the incident. Compassionate and reliable legal assistance from the Kucher Law Group. New York's premises liability laws can be complex, particularly when determining the validity of a claim and establishing the elements of a case. At the Kucher Law Group, we are dedicated to providing clarity to these matters and ensuring that our clients' rights are vigorously protected. If you've been injured on someone else's property, it's crucial to seek legal advice to understand your rights and options. Contact the Kucher Law Group today at 929-563-6780. Our team is ready to listen to your story, provide you with a clear understanding of your legal position, and assist you in pursuing the justice and compensation you deserve.